This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today I'd like to speak about a jailhouse lawyer who continues to annoy the courts of the United States and, as a result, will remain to serve his full 137 years in prison for insurance fraud and arson, a kind of conviction that will help deter insurance fraud by others. A prisoner by the name of Ali Darwich sought relief from a lengthy sentence after multiple efforts as a pro se applicant, that is, representing himself and proving the old maxim that an person who represents himself has a fool for a lawyer and an idiot for a client. In the latest attempt, Ali Darwich versus Warden Lewisburg USP and the Attorney General of the United States, filed and ruled upon by the Third Circuit Court of Appeal on October 14, 2022, Ali Darwich, a federal prisoner currently confined in the United States Penitentiary in Lewisburg, Pennsylvania, appealed pro se from a district court's order dismissing his petition for a writ of habeas corpus. The whole thing started back in 2013 when a jury in the Eastern District of Michigan convicted Darwich of 33 counts related to arson and insurance fraud, including 7 counts of using fire to commit fraud. He was sentenced to a total term of 1,647 months, or a little more than 137 years of imprisonment. He tried multiple times to avoid the sentence, only to have the United States Court of Appeal for the Sixth Circuit affirm, and the United States Supreme Court denied Darwich's petition for writ of certiorari. Darwich then moved to vacate, set aside, or correct his sentence. The district court denied the motion. Then the Sixth Circuit denied Darwich's request for a certificate of appealability. Darwich continued to file numerous unsuccessful motions for authorization to file second or successive motions under U.S.C. 2255. In 2022, Darwich filed a petition for relief under Section 2241, which the district court construed as raising 3 claims. 1, that Darwich's conviction and sentence was unlawful. 2, that he was subjected to selective prosecution because of his race or ethnicity. And 3, that the sentencing court erred by imposing consecutive sentences. The district court dismissed the petition, concluding that Darwich failed to show Section 2255 was an inadequate or ineffective remedy so that his claims could be considered under Section 224. In analyzing the issue, the Third Circuit noted that motions pursuant to 28 U.S.C. Section 2255 are the presumptive means by which federal prisoners can challenge their convictions or sentences. A habeas corpus petition under Section 2241, accordingly, shall not be entertained unless a 2255 motion would be inadequate or ineffective to test the legality of petitioner's detention. A Section 2255 motion is only inadequate or ineffective where the petitioner demonstrates that some limitation of scope or procedure would prevent a 2255 proceeding from affording him a full hearing and adjudication of his wrongful detention claim. The Third Circuit agreed with the district court's determination that Darwich failed to make the showing necessary to meet the safety valve exception. First, Darwich alleged that his conviction no longer qualifies as a violent felony. Darwich was sentenced as required by the current statute, and it was a felony. Clearly, arson and insurance fraud are both felonies. Second, the district court's determination that it lacked jurisdiction to consider Darwich's selective prosecution and consecutive sentencing claims failed. And third, Darwich has had numerous earlier opportunities to present these claims, and the fact that his prior challenges have been unsuccessful and or a new one would be barred as successive does not make Section 2255 an inadequate remedy. Even colorable claims of actual innocence, whereby a petitioner is being detained for conduct that was subsequently rendered non-criminal by a Supreme Court decision, may meet the 2255E requirement when the petitioner had no earlier opportunity to raise the claims. But they don't apply, therefore, to Darwich because he'd already raised them once and twice. The Third Circuit, therefore, affirmed the judgment of the district court. In my opinion, this case establishes without doubt that people who commit insurance fraud have unmitigated gall and deserve their sentences. Arson and arson for profit is a violent crime that can cause firefighters or innocent bystanders or tenants to be injured or killed. The sentence was deserved, and the making of multiple appeals and motions that are specious deserve sanctions, but it would do little to add to a 137-year sentence. The only sanction that is appropriate, in my opinion, is that the courts must ignore any further move by Darwich. This video was adapted from my blog, Zelma on Insurance, and is available free to anyone who cares to read it at zelma.com/blog, where you should subscribe so you can learn of future videos and future blog postings. The videos are posted on YouTube and rumble.com, and I would appreciate either a like or a rumble check mark, depending on which system you use to view the video. And you can also subscribe to my locals community and to my Substack publications. Thank you for your attention.